what's prescription. If you don't, you're gonna fail. I'm just kidding, which probably will. So you need to know what's prescription. This is why I say you need to know all areas of law. So your client says to you, okay, the matter gives you the file, and the matter has actually prescribed. What is your ethical obligations as an attorney to tell your client? All right, so number one, let's just dive straight into it. So number one, you can act. You can act in a matter where the merits may not be in your client's favor or may be unfavorable. Your ethical duty though is to inform your client and say to your client, listen, this debt has prescribed. However, the obligation to raise the defense of prescription is on the defendant. Therefore, we can proceed. Your risks are that the court does find in favor of the defendant, and you could end up with a cost order against you because you proceeded on a file that was prescribed. So it's dangerous. On the other side of that, so the defendant has to raise it, and they have to raise it via a special plea. So there's a special format, a special way in which they raise this defense. It can't just be said. There's a proper procedure that needs to be followed. And if your opponent did not raise the issue of prescription, the court cannot raise the issue. So they can't be raised in what we call mera mutu. So the court can't raise it themselves. This is something that needs to be raised as a special plea by the defendant. And so that would be your moral obligation. That's it. That's what the ethics are. It doesn't necessarily mean you need to start now panicking. Oh my goodness, it's prescribed. You need to just inform your client. These are the risks involved. This is the possible outcomes. This is some of the strong points in that, for example, it has to be raised via a special plea. The judge can't raise it, or the magistrate can't raise it. They may see it as prescribed, but they're not allowed to raise it. And your job is done insofar as advising your client in an ethical manner. All right, so that's the one part, and that's just one example of how we deal with clients, all right, and being ethically sound towards our clients. Let's use another example. Let's say that we have a magistrate who is presiding over a matter, and you are aware that the magistrate either has a personal relationship with either the plaintiff or the defendant, or maybe even one of the witnesses. And this obviously then means that the magistrate should not be acting in the matter. That's improper. It would be improper for the magistrate to act in that particular matter. So what is your obligation ethically as a legal practitioner? What do you need to do in that situation? So there's actually a number of things. When you're dealing with the court, you kind of have to be very proper about the way you deal with it. You have to, of course, approach the magistrates. I would do this in chambers. I wouldn't stand up, although I've had colleagues stand up and just tell the magistrate, I think you need to recuse yourself. I would not do that. I think the proper thing to do is to approach the magistrate in chambers, bring this to magistrate's attention or the judge's attention, and say, I believe that perhaps your worship has a conflict of interest in the matter, and that your worship should remove him or herself from the matter. If the magistrate or judge refuses to do so, then you can bring a formal application to have that particular presiding officer recused from the matter. If the application fails, you can proceed with your trial. And then, of course, you would always have the right for review and appeal. Now, just in my answer, can you understand how and why am I saying that for paper 3, you need to know law? You need to know, for example, just in the 2 answers that I gave you, you need to know what is the Prescription Act. What does that mean? What are my defenses to prescription? Because you need to advise your client. And so civil procedure falls in there. Insofar as the magistrate, of course, you need to know, again, civil procedure, even criminal procedure, and your rights to appeal and your rights to review, because that would be part of your answer. All right, you guys are with me. Okay, let's see. I just want to have a look at my notes. Okay, big one. Fees. Okay, let's talk about fees very quickly. So I want to emphasize this point because, again, I love it when it's practical, and I love it when we can actually legit make reference to practice. As an attorney, you are not allowed to share fees with anyone aside from another attorney. So you're not allowed to share fees with an advocate. You're not allowed to share fees with an estate agent. You're not allowed to share fees with any other professional.